Any divorce case involves 5 stages. The first stage is the filing of the petition for divorce. A petition for divorce is essentially a document that you file with the court and serve on your spouse, outlining what you're asking the court to give you. If you're asking to be appointed the primary custodial parent of the child, then you need to include that in the petition. If you're asking the court to award you a disproportionate share of the community estate, that needs to be included. If you're asking for spousal maintenance, that all needs to go in the petition for divorce. The original petition for divorce needs to be served on your spouse. Once they are served with the petition, then they will file an answer and a counterpetition for divorce. The second stage is temporary orders. This is often the most critical stage of the process because in a temporary orders hearing, a judge will decide, or make orders rather, governing the parties' conduct during the divorce case. This is important because a divorce case can last anywhere from 2 months to over a year. And in that period, the spouses need orders regarding who's going to have primary custody of the children during the divorce, what the child support obligation is going to be, who's going to have exclusive use of property, like the house, for example, how the bills are going to be paid, whether there's going to be temporary spousal maintenance. Those are all issues that are decided at a temporary orders hearing. If the parties can agree on those issues, then you don't need to have a hearing. You can just enter an agreed temporary order that outlines the orders that the parties are going to abide by during the case. The third phase is discovery. Discovery is very simple. It's evidence gathering. It's how we determine what the community estate consists of and what it's worth. With respect to children, discovery relates to information that we seek regarding who should have primary custody of the kids. If you're alleging fault, then you will ask for things in discovery that will help establish that one spouse was unfaithful to the other, for example. So bank records, social media profiles, text messages, financial statements, those are some of the things that we seek in the discovery process. If you decide you want to take your spouse's deposition, that's also something that we would do as part of the discovery process. So again, it's gathering all of the evidence we need to prove our case at trial. The fourth stage is mediation. In most counties in Texas, spouses are required to mediate their cases before they go to trial. And mediation is simple. It's a bargaining exercise. If you go to mediation, you will be in one room with your lawyer, your spouse will be in another room with his or her lawyer, and a mediator who will be selected by the attorneys will shuttle back and forth and trade offers until we can try to reach an acceptable resolution to both parties. You're not required to settle your case at mediation. The mediator can't compel you to settle on terms that you're not comfortable with, and your lawyer can't force you to settle on terms that you're comfortable with. Ultimately, you need to decide whether you want to settle at mediation. If we can't settle at mediation, then we go to trial. The last stage in the divorce process is trial. If the parties are unable to successfully negotiate a resolution to their case, then they have to go before a judge, and a judge will decide the important issues in the case. A judge will decide how the community estate is going to be divided. The judge will decide who's going to have primary custody of the children, what the child support obligation is going to be. If you're asking for spousal maintenance, the judge will make that determination as well. Some parties elect to have a jury trial. And in Texas, juries, for example, can decide certain issues, but not all, in a divorce case. If you're asking for primary custody of your children, for example, a jury can make that determination if you decide that you don't have confidence that the judge is going to see the case your way.